It's 11:13 and let's get started.
Perfect.
My name is Jan Schmitz from the Edmonton Pride Seniors Group. It's May 25th, and thank you all for attending our weekly Aging with Pride discussion group for the 2S LGBTQ seniors and their allies. And thank you too to our partners, SAGE and the Pride Center of Edmonton. Before I introduce our speaker, I must acknowledge that we are located on Treaty 6 territory and respect the histories, languages, and cultures of First Nations, Métis, Inuit, and First Peoples of Canada, whose presence continues to enrich our lives. I must let you know that our session is being recorded for future use on our YouTube channel. If you don't wish your image to be recorded, please close your video feed. And now, with great pleasure, I would like to introduce our speaker. Erin Lafuente is a partner at Denton's law firm and practices in the estate group. We are thrilled to have Erin back to speak to us for a second time. Over to you, Erin.
Perfect, thank you. All right. That should work. Okay. Thank you, everyone, and I do apologize. Jen, you can go to the first slide with content. So we wanted to talk today about estate planning. So we're going to talk a little bit about a power of attorney and personal directive. We're going to talk about a will. There was some commentary last time about some questions you guys had on executors and things like charitable giving. So added a few extra slides about that. And at the end, and I know obviously our time is tight, my fault, but I've added some extra slides, and if we don't get to them, this presentation can be made available to everybody as well, so you can have the slides. Jen, I don't know if that's something you've got an email list of attendance.
We do.
Yeah, so happy to have everyone receive the slides too, so people aren't trying to keep up with notes while we're doing it. But I did at the end add a little bit of information that would be relevant to us as partners perhaps pass away, sometimes parents pass away. What does it mean that we've been chosen as an executor, and what might that mean for me? What do I need to do? So I kind of added a little bit about that as well. So again, if we're talking about estate planning, we have to think about planning for both our incapacity. So I've had an illness, I've had some sort of mental decline, which is treated by doing a power of attorney and a personal directive, as well as doing a will. And so those are the documents that we're going to talk about today. And Jen, if you just go quickly through the next 3 slides, it just shows different families. You can just go quickly through them. You know, and just thinking about how do we plan for our family to be as conflict-free as possible going forward. And one of the things that I wanted to address is who is family. And I think this is really, really important because your documents need to be done in a way that identifies who is your family. And that is not always the dictionary definition. So when I make my documents, I want to make sure that the people who are important to me are the people who are going to be involved in making decisions about me. Those are the people who are going to receive gifts on my death. And I've heard a term, my family of choice versus my family of birth. And this is a really key issue in estate planning. It's one of the reasons why estate planning has to be done very meticulously, because if we use terms loosely, we end up just with biological definitions, and that may not be what we want. So doing your estate plan ahead of time is the way to ensure that you get to decide who is important and who gets to make decisions about you. And it may not be your sibling. It may not be your parent. It may be a friend who stood by you through thick and thin. It may be a child who's been adopted, but perhaps it hasn't been legally adopted by you. There can sometimes be cultural adoptions, and those aren't recognized in the law. And so we really need to make sure we're using the term family correctly in our will. Conflicts can arise between birth families and people who are important to us, and they can be mitigated by having an estate plan that ensures the people that are important to us have a seat at the table. So this would be, for example, in who gets benefits from your estate. This could be who gets to make decisions about your funeral, who's participating in your funeral. And it can be, while you're alive, it can be very important that you pick someone who will respect the importance of your chosen family and friends, perhaps even for things like visitation at the hospital. So our laws come a long way to being more inclusive, but there's obviously still work that needs to be done. And one issue that continues to be a problem is, for some, is the presumed authority of the birth family when planning is unclear. If I don't do a will, then my estate is going to go to the people that the law defines as being my family. And I've had many clients over the years who have had an unsatisfactory result because there's people that they don't consider family, people they haven't spoken to for years, people they've been involved in litigation with, who are now going to benefit from their estate rather than people that they would have chosen. Our intestacy laws are black and white, they're inflexible. So doing an estate plan with an experienced lawyer who says, okay, tell me about yourself. Tell me who your family is. Tell me who's important. Tell me who you're excluding and maybe why are you excluding them. That information is vitally important to ensure that your estate plan actually works. Jen, if you can go to the next slide. Okay, so the first thing that we were going to talk about was planning for incapacity. And so this is if I've become ill, I've had an accident, perhaps I have a diagnosis of Alzheimer's, dementia, something like that. We need to plan for that. It's important to do so because once that event has happened, once I've lost capacity, my ability to do so is lost. So if I haven't done this planning, then I'm going to be in a situation where I have no control over who is the decision maker. I have no control over providing input into what kinds of decisions should be made. If you go to the next slide. Perfect. Now, important to understand that we live in an age of privacy. We live in an age of red tape. So when my loved one goes to find out, how much do I have to pay Upcore this month? Are my bills paid up to date? I'm in hospital and they just want to make sure everything's good. They're going to get turned down. They're going to be told that, that's not information that they can have. This can cause some very significant stress. It can cause financial harm. So the way we go about making sure that the person has access is to do a power of attorney, which we'll discuss on the next slide. Okay, so power of attorney is done to ensure that there is a person or people who can make financial decisions for me at a time that I cannot. When I'm doing that, I am picking in advance who that person should be. I have no obligation to pick a particular person. I get to choose who I feel is trustworthy, who has good communication skills, who makes decisions that are in line with the kinds that I would want to make. And I appoint them to be the decision maker for me. That person then can utilize that document and find out how much I have to pay on my power bill. They can renew my mortgage if necessary. They can sell my property if they have to, say if I need to move into a care facility and I need to sell property in order to pay for that. So having these things in advance of losing capacity is vitally important. Now, there are two kinds of powers of attorney. Very important to understand the difference between them. The first of them is rather obvious. It's called an immediate power of attorney. And what that means is it is a power of attorney that as soon as I sign it, it takes effect. So I sign it today, and that means today, the person I've chosen as my attorney could make decisions on my behalf. We wouldn't normally choose to do this unless I had an illness or I had a diagnosis where I might be getting progressively worse. Perhaps I'm going to be out of country for a period of time. Those would be times when you do this. For the most part, we're going to do what's called a springing power of attorney. And that is the kind that isn't taking effect the day I sign it, because I don't need someone to take over my affairs, and I don't want someone to take over my affairs. I want to maintain control. And so I've signed that, and it says, when I lose capacity, when two doctors indicate that I can no longer make reasonable decisions, then this person can do that on my behalf. Very, very important that you understand what kind you are giving. And if you've already done one, take a look at it and see if it has a clause that says this does not take effect until. And if you see that clause, that means you have a springing power of attorney that will spring into action when I need it and not before. You can go to the next slide. The companion to that, of course, is, money is important, but it's not everything. So we need to think about who would make decisions for me about my health and personal matters. So where am I going to live? Am I going to be staying at home? Is my attorney, who's in charge of my finances and who can be the same person, but may not be, going to be asked to pay for perhaps home care to come into my home and keep me living at home as long as possible? So those kinds of things should be specified in the document. We deal with life support. We deal with medical intervention. What kinds of care would I want if I was not expected to recover from my illness? Do I want to be kept on life support? Do I want to have feeding tubes? All of these things can be explored. Very important, I think, to be specific, to speak for yourself now, because you may not have that opportunity later. So if you can give really good guidance in the document, you can make sure that people reading it down the road are going to do for you what it is that you would want. When we don't do these documents, of course, we're stuck with a few different unwanted options. That is, people who I may not pick being allowed to go to court and applying to make decisions for me, and they may not make decisions that I would have made. This can be very important. Again, when we think about that, who is my family? Who are the loved ones that are important to me? Who sometimes there's some disagreement between family members and other loved ones in my life as to who's really important. And so it's important that that document specifies that. I mentioned earlier about, defining family and making sure that the person you pick is going to respect the other people that are important in your life. And this can be really key, because the personal directive appoints an agent who actually will have the authority to determine who you associate with. That's actually one of the powers given in the document, and it's given by the legislation. So it's really important that that person respects and understands and values the relationships in your life, because they could prevent people from seeing you. They get to decide who the nursing home lets in, who the hospital lets in. So really important there. Medical assistance in dying can also be addressed in this document, although the agent under the law at the moment doesn't have the authority to make a decision about medical assistance in dying. It can still be quite instructive in terms of quality of life issues for you. You can move forward, Jan. Okay. The alternative, if we don't have these documents, is it's an undesirable state. It is a situation in which I no longer get to be the decision maker. The power that I had to pick, the power that I had to direct what I wanted is really lost. I mean, I may still have some room in the discussion, but my capacity has been diminished. And unfortunately, I find more than that I like in the law, the voice of those who are losing capacity is really not respected as much as it should be. And so we may not get to hear what you want. There is, though, of course, a mechanism where someone can be appointed. It's done through the courts. It's an adult guardianship and trusteeship order. The difficulty with it is that, as I say, you don't have a say, but it costs money to apply. That is quite significantly more money than it would have cost to do the power of attorney and personal directive. It is a significant lack of privacy, because all of my medical information, all of my financial information becomes part of a court record, and it gets filed at the courthouse. And it's really available for anyone to see. As well, the people who are going to apply, they have to do so by providing a criminal reference check, a credit check, and personal references. And again, there's this presumed order of preference in the law that gives a lot of priority to certainly spouses and children, but after that to siblings, to parents, etc. And that may not be the relationships that are most important to us. It may be a trusted neighbor, a friend, people who really have been important parts of your life. And while it's not impossible for someone like that to be appointed under a guardianship and trusteeship order, the law just tends to presume otherwise. The law presumes a closeness with our biologic family. So we probably want to mitigate against that and make sure that we get to pick. Those people might be important to us. Maybe one or two of our siblings are important to us, and another one we just don't see eye to eye with, which happens from time to time. If we go on to the next slide. I've tried to be quicker in dealing with the power of attorney and personal directive today. And the reason for that is that a request was made in terms of today's presentation to concentrate a little bit more on the after death side. So I've kind of gone through that quickly, but happy to answer any questions at the end, or if you have any questions, you can give me a call, absolutely. After death, of course, we're looking at doing a will. We're looking at doing before death, but for managing our affairs after we die. And the really the key thing is who is going to be in charge, keeping our family out of court and defining who those important people in our life are. Next slide. Okay, so when I'm going to do a will, there are certain things that I really need to consider. The first of those things is picking an executor. This is probably the single biggest decision that you're going to make. And in my experience, it's the one that most impacts how the estate is going to go. Because if you pick the right person, they're going to be able to do so, avoiding conflict, not procrastinating, making reasonable decisions. If you get people who are not well suited to the job, they tend to act in a way that creates suspicion or that really amplifies conflict, or worse, they do things that are in self-interest. So you want to pick someone who's trustworthy, who perhaps has some business acumen, understands sort of the nature of your estate, especially if your estate is more complicated. You want to pick someone who can manage that. Sometimes we don't have someone in our family or close friends that we think would be really good at doing that. And there's a few reasons why that sometimes happens. It can be just due to a smaller circle of family and friends. It may be because family and friends don't live in Alberta or they don't live in Canada. It is preferable that your executor, or at least one of your executors, live in Alberta. And the reason for that is that an executor who does not reside in Alberta can be required to post a bond, because our courts are not sort of, I guess, legally in charge of them in the same way, because they're non-residents. So we do want to pick an Albertan. Certainly we want to avoid having non-resident executors act alone, non-Canadian residents. That can cause you some tax issues that we want to avoid. And therefore, sometimes we will be in a situation where we just don't have anyone who's suitable here. And a lot of people can be concerned because their peers are of the same age as them. And their concern would be, well, will these people still be here when I need them to act? And so that can create a lot of stress for people. So sometimes what we can do is consider other options. One simple one that is sometimes available would be to contact the law office that you're doing the estate planning with. So for example, if you're to chat with me, we can be appointed as an executor or even sometimes as an alternate executor, so that if those people you've picked do pass away before you, we can step in. There's obviously some cost consequences to doing that. And so it's something we want to always balance out the pros and the cons, because obviously there's going to be a legal expense to having a lawyer act as your executor. But it sometimes can be good, because if your estate is going to be complex, either in terms of the assets or anticipated disputes with friends or family, it can be nice sometimes to put that on the shoulders of someone who's going to deal with it from a business aspect and not have to have it weighing on their personal life. So I think that can be good. There are other options, and that would include retaining the services of a corporate trustee, such as a trust company. So obviously there's a few trust companies in the city, Scotia Trust, Royal Trust, they all offer these services, and they would then be appointed as your trustee. They would manage your estate. They would deal with assets and deal with your taxes and make sure that the property gets into the hands of the beneficiaries in the best and most tax advantageous way. So those are all options that are available to you. And I would say that if you're thinking of going with a non-friend or family, you're definitely going to want to talk to the lawyer about the pros and cons and get a good sense of that cost to decide if that's right for you. And if you're going with friends or family, certainly if you're going with someone, perhaps it's not your spouse, it can be really a positive thing to ask them if they're willing to do so, because this is a very big job. It's actually surprisingly more work, I think, than people know. And so we want to make sure that people are comfortable with doing the job. Now, once I've chosen the person, now I have to figure out, well, what does the roadmap look like? What am I asking this person to do? And that's where, again, defining who those important people in my life are is really important. Who do I want to benefit? And when I'm doing that, I need to think about if there are categories of people that I want to benefit, but perhaps they shouldn't get the money right now. So that can include children. And when I say children, I'm not necessarily restricting that to people under 18. So young adults, usually between the ages of 18, 25, sometimes even to 30, we might not want them to get a large amount of money. So we can create a trust for them that says that they don't get full control of the money until a certain age. It can allow us to provide some guidance, perhaps get a mentor involved, get some investment advice. We can create a trust. We can also use that to protect the assets from potential divorce in the future if our children were to get divorced, and I'm worried about that, so we can kind of keep the assets in a trust. So that's one option. Another option that can be really important would be considering spousal relationships or common law partners, adult interdependent partners. We might want to create a trust where we provide them with the income from our assets during their lifetime, but we are not providing them with the actual outright asset. And the importance of this can be that I might have children or nieces and nephews or friends or family that I want to ultimately get my estate, but in the meantime, I want to ensure that I've preserved the value of that for my spouse or common law partner. And so they would get the income from that, and sometimes they can even encroach on the capital, and those parameters are set up in your will. And they can take that income and they can have, live their lifestyle with the assistance of my estate, but I'm keeping the assets ultimately in my estate. So that's another option that can be set up. If I've got a business and we really need to make sure that my business is protected, that I've got a plan for who's going to continue it, who's going to operate that business. Is it going to be liquidated? Is it going to continue? Those are things that can be dealt with in your estate plan. Significantly important to understand what is in your estate. Okay. Too many people do a plan and they don't actually know what they have. They haven't sat down and looked at their assets and their liabilities and thought about what occurs outside of my estate. So when I pass away, anything that I've owned jointly with someone, particularly if it's a spouse or common law partner, is going to become the asset of that person on my death. It is not part of my estate. Okay. If I've done life insurance, for example, and I have named a beneficiary, that person is going to get that money outside of my estate. And that can be great. That can help them get the money more quickly. It can avoid that money getting tied up in my estate, having perhaps to pay my creditors. But this can be an important consideration, because if let's say I got $1 million of insurance and I pay it to my spouse outside of the estate, but I'm going to have some debts in my estate that have to get paid, perhaps if it's income tax on my death, that money is now no longer available to come into my estate to make that payment. That might be what I want, but I do want to consider that, because do I need that money to come into my estate to pay down my debts in order to make sure that those get taken care of, especially if you're giving the money in the insurance policy to someone who is not getting the residue of your estate. So that's really important. I did an estate administration for someone years ago who had done a will, very simple, tried to give the estate to his 3 kids, But the idea was more to the daughter because she'd really cared for him for many, many years while he was sick. And the idea was great. And actually, everybody was on board with the idea, including the two sons. But the problem was that he didn't, as far as I can tell, didn't give good information to the lawyer, or the lawyer didn't ask for the good information. And your lawyer, I think I said this to this group last time, but your lawyer should be nosy. Your lawyer should ask you lots and lots of questions about your assets and your family and your liabilities so that we can make sure the plan works. And so in this case, this person, maybe didn't have that conversation. And so gifted the property 2/3 to the daughter and 1/3 to the other, but didn't account for the fact that there was a whole lot of assets that were passing outside of the estate to the boys. So the two boys ended up actually getting way more than the daughter, who ended up getting the house, but the house was encumbered with all of the debt that he'd accumulated in his lifetime. So she ended up having to pay all of the liabilities from the asset that she got. And when the math shook out in the end, she got far less than the boys, and certainly not the 2/3 of the estate that they were hoping for. So that is an example, though, of a plan that made sense on paper but didn't work in reality, because my impression is the lawyer and the client didn't sit down and say, okay, we need this to work. Estate planning lawyers should not be just grabbing a precedent from a shelf and saying, yeah, this one will work for John, and just put your name on it. It needs to be a really considered process. So you should think that the lawyer is too nosy. I think that's a compliment. When someone thinks I'm really nosy, that's a compliment. It means that I'm doing my job. I am finding out who is your family. What do you own? What liabilities do you have? What's important to you? Those are really important questions. As an example, I had a meeting with a woman about a year ago, and we were doing a plan, looked to be very straightforward. And the idea was, everything to my kids, and then if my kids pass away, it will go to their kids. And so I'm drafting that. And just as an aside, we were having a conversation, and it came to light that one of her children was in a relationship. And the woman that he was in a relationship with had children from a previous marriage. And she absolutely considered those to be her grandchildren, notwithstanding they were not biologically her grandchildren. Had we not figured that out, and if I had used the word grandchildren in the will, arguably they would have been left out. And so it was really important. And again, in speaking to that issue of defining who your family is, all that we needed to do to make that right was to have a sentence that says, I consider the children of so-and-so to be my son's children and to be treated as my grandchildren. That one simple statement would have avoided a potentially significant litigation, or worse, the actual disinheritance of those grandchildren. So really, really important. You want a nosy lawyer, and you want to put in the time to make sure that when you fill out the questionnaire, you do a good job of it. The quality of the work that you put into it, the quality of the work that your lawyer puts into it, that's what's going to get you a good product. The two other things that I like to ensure that we talk about very, very carefully when it comes to wills are personal assets and funerals. The reason that these are so important is this is where the fights start. Imagine that you've just passed, everyone's emotions are raw, and now we're deciding what to do with the watch that you got when you retired. And 4 people want it. One of them is the executor. You're just asking for trouble. Executor takes it for themselves, they're going to be considered to be greedy. The executor gives it to the other ones, they might be mad, plus the executor's feeling like they're not getting what they want. We need to have a system. We need that system to come from you. And so right in your will, we need to say, this is how I want you to dispose of my personal assets. I might leave a list. My grandma had a scribbler that had everything written on it. That's if you didn't find your name on the back of something hanging on the wall. She also would do that sometimes. But we could go to that scribbler and say, okay, you know what? 3 of us may want this, but grandma must have talked to Jackie because Jackie's getting it. And that was easy. So the first thing we generally will say is, I might leave a list. And if I leave a list, I want my executor to follow it. But the reality is, we can think we know what's important and we can start gifting things. Sometimes we gift things that people don't actually want, and we don't realize that some of the valuable stuff, we don't even put that value on it, but it's important to our family members. And as a result, I like to have a mechanism that deals with the stuff that we don't think of. And so we will often do like a lottery system where it's everyone says what they want. And if more than one person wants, we put their names in a hat and decide who gets it. Or we might, if, for example, these are children, go in birth order and say, okay, oldest to youngest, youngest to oldest. Unless, of course, you're a middle child. Middle children will never, ever give me those instructions. Middle children will shudder at the very thought of an oldest to youngest birth order system. And I know that because my own sister was the one who said to me, don't you let mom do it that way. She was the middle child. So the other thing, though, that can be really important is funerals. Funerals cause all sorts of problems because there are so many value-laden reasons why we might want something over the other. Burial, cremation, whether it's in a church or not in a church. And our executor may not agree with us on that, may not know what we want. And so what we like to do is make sure that the really key stuff, am I going to be cremated? Where are my remains going to go? That stuff gets put right in your will for the executor to read. It is vitally important to understand that it is the executor who has the authority over the funeral and the body. And that can be really important because as we age, sometimes what we've done, I've had a lot of clients who said, you know what, I no longer want to put my partner as the executor because I think that they maybe would find this overwhelming. Fair enough. Perhaps, they have had some health issues that make this job a little bit too big. But recognizing that if we don't pick them as the executor, then they're not going to be the one who gets to have those decisions about the funeral. And so what I would do in that regard is create a clause right in the will that made it clear that I expected the executor to meaningfully consult with my spouse or perhaps with my children or whoever it is that I wanted to include. So that can be something to think about. If you can go to the next slide, Jen. Okay, so another topic that can be important is charitable giving. There's a few reasons why this is important. The first is we all have things that are important to us and organizations that we want to provide for, I think that, might reflect on our values and provide a legacy that we would be proud to leave. The difficulty can be that we can't afford this during our lifetime. Most of us don't have the disposable income to give something very significant to a charity on a regular basis or even on a one-time basis. And so we can use planned giving as a way to do that in a way that's going to be more affordable for you. So you can make a gift in your lifetime through your will that, of course, won't be given until you pass away. So you might not have been able to afford it during your lifetime, but you can on your death. Certainly, you can do this and you can give all of your estate to charities. But I think sometimes people are worried that if they do that, then they're not going to be able to provide for friends or family. And so you can give a small percentage or a gift for charitable purposes. It can have a huge impact for the charity, but through some meaningful tax planning, you can actually find a way to do it where you're not actually changing what the friends, family, perhaps your children would receive, because the benefit I'm going to be getting from making that donation on my death and the credits that my estate would receive might actually reduce the taxes payable to CRA in the same manner as the gift that I'm giving. So there can be some very, very significant tax advantages for gifting on death that would allow us to, provide relatively the same gift to friends or family, but the charitable gift is only reducing what I owe to CRA. So that, of course, is not something that is, easy to determine. It requires you to consider your income levels, your tax issues, your assets, what might be payable in tax on your death. So you need to work perhaps with the lawyer and an accountant to figure out what the right number is. And this is one of those things as well, that if you pick a number, maybe a specified $100,000, it might need to be reviewed from time to time to make sure that you have the right number and that you're not going to gift more than your estate really wants or less than perhaps the best taxable advantage. So that is something to have some discussions with your estate planning lawyer about. Next, an important issue that we need to make sure that we consider is avoiding arguments over gifts. So lots of us will have given loans or gifts to friends or children during our lifetime. And one of the really significant issues that I find is that there's a disagreement on my death about what did I mean? And usually the people that I've given it to will say, oh, that's just a gift. But the other people in my life may have known about the gift. They may not have, and they're finding about it after. And they figure out that just makes it seem like unfair. So for example, if these are to children, and I've given one children money to go to university and the other two didn't go, did I mean that to be an advance on their inheritance, or did I mean it to be a gift? And so our will needs to specify that. Because some of the really ugly litigation I've been involved in is about whether an executor should have been forgiving a loan or should have treated it as a gift, or whether the executor should pursue it. And an executor can find themselves in a really tough position if, for example, two of the children believe that they're supposed to go and collect this will from the other child's share of the estate, and the other child believes it was a gift. So again, we're creating a situation with that uncertainty that's going to cause some difficulties amongst my loved ones. We can make that very clear in the will, and we can avoid those confrontations. Additionally, just as a piece of financial advice, if we are gifting money and it's being used to purchase a house or for university, etc., you're going to want to take a promissory note, or in the case of real property, perhaps have a mortgage to secure that and to ensure that you're going to be able to recover those monies later. Next. All right. Challenging a will. So in Alberta, we have a pretty robust system of respecting testamentary autonomy. We believe that people should be able to give their property to the people that they want to, for the most part. There is a small category of people who have a right to support from your estate, and that includes a spouse or an adult interdependent partner or common law partner, as well as children in certain circumstances. So children who are minors, children who are over 18 but going to full-time university up to the age of 22, and adult children who, by reason of mental or physical disability, are unable to earn a livelihood. That category, those categories of children, could challenge a will if they're not given something that they consider to be fair in their circumstances. So those challenges sometimes happen. And what the court does is determine what is the obligation to provide for that person, what would be fair, what do they need, and can adjust the will to provide the support that the court considered to be fair. Outside of that group, and including adult children who are able to earn a livelihood, it doesn't matter if mom or dad did not give them anything. I will get those called off, very often, and my answer is to say, sorry, dad doesn't have to give you anything. And that's the law in Alberta. It is not the law in other places. BC, for example, does allow adult children who are capable of earning a livelihood to challenge a will based on fairness. So Alberta is actually a good place to be if you want to do something creative in your will. Now, there are two other ways that people can challenge a will. So when people call me and say, it's not fair, dad should have given it to me and I didn't get anything, he gave it all to the Humane Society and I'm mad, my answer is going to be, sorry, that's nothing I can help you with. So then the wheels will start turning and they think of other ways to challenge it. And so they'll often try to say, well, dad didn't know what he was doing, or that they influenced dad to give it, not giving it to me, etc. And so the best way to mitigate against that is to work with a skilled estate planning lawyer who knows the red flags to look for and who will document in their file that, you know, you were clear in what you wanted, that you weren't influenced by anybody else, that you were of sound mind, and be able to testify for you down the road about your capacity. And that's one of my jobs as an estate planning lawyer. It is actually to keep those notes and records so that, you know, if you die 25 years from now, I'm going to be able to look at my file and say, you know, Jan knew what she wanted. Jan came in, she was clear. She knew who her family was. She knew what she had in the bank. She chose to do this because of these reasons. And it's really important that I have those good notes, because it's a weird area of the law. I know at some point someone's going to need to rely on this, but it may not be for a few decades. So I need to have those good notes. And so that I can help your executor address any challenge that might come in terms of capacity or influence. These can be really big questions, especially in situations where you may not be close to certain family members who feel they have a right to your estate, but who maybe aren't important to you and you don't want to include. And as a result, if you're doing something that would be perceived perhaps as unusual or unfavorable to those people who feel the right to inherit from, you know, from their uncle or from their aunt or from their parent, it's best to address it with counsel, ensure that you've dotted those I's, you cross the T's, and we know, why are we not including that person? Why are we including this neighbor? Right? Because those, the ones when we give to our neighbor, those neighbors may have been through us, there for us through thick and thin. They're as close to you as family. They're really important to you. But what's going to happen? Like, people who think that they ought to receive from you are going to challenge that and say, oh, the neighbor Fred, you know what? He was always looking out to try to get something. He influenced him. This is why he did it. We need to make sure that we have good notes that can say, well, why did you give to Fred? What's Fred's role in your life, and why didn't you give perhaps to your son or your daughter or your niece or your nephew, whoever those people who may feel they have a right. I feel really strongly about telling people they have no right to your estate, but I can tell you that the people who think they have a right to your estate, usually they've practically spent your estate in their head before they've even been told that they are a beneficiary. And it's those people who get, it's like a dog with a bone in this challenges. So it's really important that you have that good connection with the lawyer and making sure that you can, that lawyer can sustain any challenge. Next, Jen. Okay, I know we're running out of time. So what I have left, I've done sort of the estate stuff, but what I have left, I'm just going to go through really quickly, because this is more, okay, my loved one has passed away. I'm an executor. What do I need to do? So I think the most important thing is you'll have these also as a take home. But it's really important that you understand, if, you know, are you the executor? Plan the funeral, cancel any identifying information. Tip that I would give, funeral homes offer these services where for a fee, they notify everybody. I would tell everybody, take advantage of that. You're going to have enough work to do. You don't need to be doing all that paperwork. So they're very, very good and efficient at it. And I don't find they're very expensive. Next. All right. How to pay debts. This is hugely problematic. And this can be important too, as we age and we're worried about our loved ones being able to pay our debts. I've seen people think they have to give money to people in advance so that they can get things paid. There's very practical ways to do this. One thing, prepay for your funeral. Pre-plan it. That's a very, very simple thing that you can do. But if we don't assume that they're not going to be able to access your money to get these paid. I've always had success before the grant of probate is issued, going to the bank with payments for funerals, credit cards, utility bills. As long as there's money in the bank and that bill is in your name, you're going to be able to pay it. So, or in your loved one's name if you're the executor. After the grant of probate is issued, which we'll quickly talk about, the executor can go to the bank and access anything to pay the bills. But in that short term, we don't have to generally worry about people having access to the money, because as long as the bill is for me and I'm the deceased person, the bank will authorize the payment directly to the funeral home, directly to the credit card company, etc. Next, grant of probate. I wanted to talk about this because this is something that most people are confused about, and it causes a lot of trouble. What is a grant of probate? It is essentially just a rubber stamping of your will, okay? Your will is your will and it's valid, but the bank, land titles, they're concerned that there could be another will out there. How do they know that this is your last will? So this is the process by which your executor applies to the court to say, here's the will. Can you please give me the authority and let the world at large know that I have the authority as the executor under this will. So you apply for that. We live in Alberta, so it is not expensive. People are often worried about avoiding probate. You don't need to be doing that in Alberta because we don't have probate taxes. We have a small fee that gets paid at the courthouse, very, very small. Obviously, there's legal costs for applying for it, and I have a quick slide on that, but it's not something you need to avoid. It takes a couple of months, and once you have that grant, you are essentially in the deceased person's shoes, and you can do anything that they could have done. Next. Okay, who gets a copy of the will? I just would say to people, the will doesn't need to be super, super secret. If people think that they're in the will and they're not, it's best to just show them what the will says. Otherwise, they're going to have these big schemes in their head, these conspiracies. It's better to just show them what the will says, okay? Executors have to pay taxes. We know that we can't avoid them. This describes the taxes that have to be paid, but essentially it's any previous year that was not filed, any part year for which you lived. So if you died in 2022, you have to do 2022 up until you died. And then for any year that your estate is earning any income after that, your executor will also have to file taxes. This is why, though, it's not an easy job. It does continue for a few years, and there's a lot of work to be done by the executor. Next. Clearance certificate, and I apologize, that is so small, I can barely read it, but you'll be able to see it on the slides when we send it. But a clearance certificate is important. As an executor, one of the things people worry about is that they're responsible for the person's debts. You are not, okay? You're responsible that you don't ignore any debts when you bring in their assets. So if I were to bring in $100,000 and pay that $100,000 out to the beneficiaries, and I didn't pay the Visa bill or I didn't pay CRA, yeah, then I'm going to be responsible. But if there's $100,000 in this estate, but they owe $200,000, I don't have to come up with that extra money. Okay, I can only do it with what I have. One way, though, that you can be responsible is if you don't get clearance from CRA. So Canada Revenue Agency requires you to apply to them to say, did I pay all the taxes for this deceased person? And once you have that clearance certificate, it does take some time to get, then you can rest assured that they're not coming back to you and saying, hey, Joe owed more money. Very, very important step. Next. Okay, I think for the rest of us, we'll probably just leave because I know you guys need to get going, but I want to just give you this advice because I think it's super important. Grant of probate. There's a small charge of the court charges, not significant, no probate taxes in Alberta. Legal fees. You should negotiate those. If you are an executor, do not just go to the first lawyer, even if it's the lawyer who did the will. If they're saying to you that they're going to charge you an amount plus a percentage of the estate, it's important to understand we are allowed to do that. It is authorized. At my office, for example, we do not do that. We charge a flat rate. I didn't earn that money. I don't think that I should be getting a percentage of it on your death, but it is very, very common. So it is important, especially if you're, an executor, you've been appointed and you just think, oh, I just should go to the lawyer who did the will. You need to ask that lawyer, what are they going to charge? Compare the rates and shop around just like you do for anything else. Just because they did the will doesn't give them, carte blanche to charge what they want for doing the grant of probate. Executor can also charge a fee. So that's one more important thing to understand, that if you're the executor, you should charge for your services, but understand that it is taxable income. So you will have to pay tax on it as if it were essentially your employment income. So that's important to understand. I believe, Jan, that the other slides relate to well, what you would need to do in terms of accounting to the beneficiaries, and then power of attorney and personal directive. I've said, well, what does an attorney have to do? And what does an agent have to do? So I think they're going to be good information to have in your back pocket. So when you get the slides, you can look at those, but we don't have to do that today. If you just go to the last slide, Jan, I've left my contact information there. I do apologize. We had the slide issues today, so I had to rush through the last ones, but I'm always open for an email or a call if you have questions. Happy to do so. You know, my clock does not start running because you dial the phone. So unless you've opened a file, you're not going to get charged. Just give me a call if you've got a question. If you're not sure if your documents are good, if you're not sure you need new ones, maybe you don't. Just give me a call. I'm happy to have that conversation with you.
So we understand if people need to go, it is a little bit of afternoon, but if anyone willing to stay on the meeting, I'm sure Erin would entertain a few questions if anyone has any. I did have one, Erin. Is there a definition to the word meaningful?
There's not. We could, I mean, it's something that you could flesh out more. I use the word meaningful because I'm trying to mean more than just inform. So when I use the word meaningful, I am trying to say I really expect them to engage in a conversation. But that's a good comment. And I think it's one of those things where we could flesh that out a little bit more. So yeah, I use it to mean more than cursory is what I mean it by. But I think, you know, the law is all, unfortunately, all about picking holes in words. So we could work on that word a little bit. I see a question in the chat. Yeah, so if one has made arrangements for burial, etc., can the executor change that? Generally, no. So an executor has to follow your wishes if they're known. So if I've gone ahead and planned my funeral and I've said I'm going to be cremated and it's going to be held here, etc., that's going to negate the executor's ability to change. Subject, of course, to I may have had a plan. I may set out that I want X, Y, or Z, but if my estate can't afford it, the executor is going to have to modify that to be what's reasonable. We do definitely have to modify it if we're not going to be able to pay the liabilities of the estate. We cannot have a $50,000 funeral because our creditors in the CRA, they will come after you. I think Cheryl had a question.
Yeah, thanks. And great presentation. Thank you. Our relationships are a bit more complex, I think, than the average heterosexual who gets married and has 2 children and so on. There's 2 questions I have. One is so we move through relationships. So oftentimes we'll have common law relationships that are established, and then we'll break that relationship off and start a second relationship, and in some cases a shorter term relationship because now we're older and have reestablished ourselves. Is there any conflict that happens between previous common law, previous relationships that you might have had, even long term, and now, of course, your new relationship, which is established? And although I must say the greater problem I see is that we actually don't change our wills to reflect our changing life circumstances. And the second question is we actually had a financial planner recently tell us, I'm actually in a longer term relationship, like into the 40 years, who said to us, you should get married. That it would make your life so much easier if you two just got married, and there would be no issues around your estate. That your estate as it is, there shouldn't be any issues because you've been together for so long. Although we have a unique situation is we actually haven't co-joined lots of our financial matters. So, okay,
really excellent question, and I was trying to cover that off a little bit when I was talking about defining family, defining who's important, because the first part of that is we might know who's important to us, but if it's not apparent to the outside world, or there's an opportunity for greedy people to come in and say, I don't really think, I don't recognize that relationship, We want to avoid that. So I think you answered your question itself in the first part, which is we need to update documents. So if there's a major life change, and if that's a new relationship, even if it's a new relationship in which I don't plan to provide for somebody in my will, I still need to review my documents, because I might need to say, I have not made changes to my will. This person is not my adult interdependent partner, because that question of whether someone is an adult interdependent partner can be quite challenging. Now, I'm not sure I understand the advice to get married. I think that has to be something you decide to do because you want to get married, not because you want to have a certain outcome. You do need to have a good estate plan. There is an alternative to marriage, and that is an adult interdependent partner agreement. So people who reside together in a long-term relationship of interdependence can become automatically adult interdependent partners. And this is probably its own whole presentation as to what is an adult interdependent partner, because our legislation just made it intentionally complicated, I believe. But we can choose to be adult interdependent partners by entering into an agreement. And so by doing that, you can acquire all the rights and status of an adult interdependent partner, which includes rights on death. So there is very, very little difference between a spouse and an adult interdependent partner on death. You have all of the same rights, and the only one that is different is the Dower Act. The Dower Act is an ancient piece of legislation that most provinces don't still have. We do. That provides married people, and it has to be a legal marriage at this point, with a right to reside in a property or earn an income from a property that it was owned by their spouse. Okay, so there's that one small thing. But otherwise, an adult interdependent partner, which I assume you would qualify as, has rights to family maintenance and support, so would be able to challenge a will if it didn't provide. If there was no will, an adult interdependent partner would still have the first right to be the executor in an estate, and would have the first right to be the beneficiary of an estate. So there's not a lot of changes there. In terms, though, of the complexity of relationships, I was thinking that in trying to define that family, that's an important part of it, because the law, as I said, we presume certain relationships are above others, and we give priority to certain relationships, and it may not be what we want. And that's why it's important that we do a will that says these are the people that are important. Maybe it's not your siblings. Maybe, yes, it's your parents, but if your parents passed away, you would not want it to go to your siblings. You would want it to go to your partner's siblings. Those things have to be spelled out in a will, or you're going to be stuck with those kind of presumptions. The key thing that you said, though, and I want to try to cover off all the elements of your question, though, is the changing of relationships. Significantly important that you do change your will. The only thing that automatically changes a gift in a will is divorce. So that is another one where the married people, when they get divorced, it automatically revokes anything that the spouse got, but separation doesn't do that. So we definitely need to be looking at this. So I would say it's key to look at your plan. It's key to revisit your plan. Any life changes, acquiring a new property, breakdown, etc. There's a question about, is there divorce in common law? There is not divorce. There can be separation. There can be, if you have entered into an agreement, you can cease that, you can end that agreement. Another topic would be, for a whole other day, would be cohabitation agreements. Those can be significantly important if you're entering into a new relationship, especially later in life. Because if you're entering into that relationship, you might want to keep those assets separate, either on the breakdown of that relationship or if you pass away. Because I might want to be dictating what happens when I die, whether or not that person's going to get something. So those are all things, certainly I think common law partners the real challenge, I think, can be in defining. And, you know, a 40-year relationship, it's not going to be hard for us to know that you have an adult interdependent partner. It doesn't matter that you haven't co-joined a bunch of accounts. It's that relationship of interdependence over many, many years and living together. But I've had other situations in which there was a question about an adult interdependent partner. And some of these have been situations where maybe the family, the biological family, didn't really accept the relationship. And as a result, sometimes the couple have kept certain elements of it hidden from everybody else. So you get to a situation where maybe even fairly, the family doesn't think that's a serious relationship. And so then you have a fight about whether someone really is the adult interdependent partner. So one way around that is to put in your will, my spouse or my adult interdependent partner. And sometimes we'll just call it a spouse. And that defines it. Or entering into an actual agreement. Now, if you were going to do that, you'd want legal advice about the consequences of that, right? Property, what happens on breakdown of the relationship.
I know we're significantly over. If any of you have to go, it's okay to do so. I see that there were 2 questions in the chat room. Maybe Erin, if you have time for those 2 questions.
I sure do. Yeah.
One was from Joan, and then one was from Alvin.
Okay. So Joan's question was, can I do so without seeing a lawyer? Put my wishes together. You can. There is something called a holograph will. It is legal in Alberta. It is a handwritten, one key really important thing, handwritten, not typed, 100% in your handwriting. You can do a will that way. And you can say, this is what I want. I advise against them for a few reasons. One is I have literally not met a holograph will that didn't cost more at the end of the day to interpret than if you'd gone to see a lawyer in the first place. Because especially if you go to an experienced estate planner, you will use a word and I will know to say, hey, but what do you really mean by that word? When people are writing their own, they are often just thinking about, hey, I'll just do this, or they forget. I've seen so many where they give a whole bunch of their property and then they forget to give the residue of their property away. And now we have a will and partial intestacy. So it can be really complicated. It is doable. I wouldn't recommend it. There are also those kits that you can use. Nothing wrong with them. I still wouldn't recommend it because I think that there's legal advice that can make sure your plan works. But in a pinch, that would be a good option. That being said, call around. Law firms, will give you a ballpark as to what it would cost. One thing that I often offer people if they're feeling that it's expensive, I'm happy to have you pay me over a few months. Just if you tell me outright at the front, like, hey, I need some accommodation, that doesn't bother me in the least. So I would rather you do that and do a good job of it than not. I think the other question related to personal items. Let me just go back.
Designated jewelry. What is the best way to designate jewelry to beneficiaries?
Yeah. Okay. So I think the easiest way to designate beneficiaries, jewelry to beneficiaries, is just to have that note that says, I'm giving this person this, this person this, this person this. However, if you are a person who really values things being fair, and you're worried about, if I give Jan this necklace and she's getting a third of my estate, now she's gotten really more than a third. Personally, I am the second child and I hate concepts of fair. I don't want to hear about it. I'm not the person who wants to have everything be equal. But if you are, then you need to include a mechanism that says, she's to receive this, and then that's included as part of her equal share. That's one option. I don't like to do that. I think it creates extra problems. So unless something was very valuable, I would just give them the stuff. That's, I think, the simplest way. But that would be definitely a question to sit down with your legal advisor and say, okay, here's my stuff. Here's what I want to give. Here's what I think they're worth. If you think that it's important enough to have them valued, we can include a clause in there that says, I want you to figure out what these things are worth. Sometimes we way overvalue them in our heads. Sometimes beneficiaries way overvalue things and think that mom has this massive jewelry collection. No, most of it is, you know, costume jewelry or meltdown value, right? So I think that that's easiest is just to gift it outright, but we can talk about different options. I think that's all the questions I see.
That's all I see too. Erin, thank you. That was just amazing. There's so much
I am
information
so
here.
sorry for the time delay, but I hope I made up for it in information.
Well, thank you all for coming today. And I hope we see you all next week when we will have Amanda Harriman-Gotian and Punch Jackson, who will discuss the Men's Shed program. And save the date for June 22nd, when we will have an Aging with Pride movie night. We'll be hosting another film screening, Tain't Nobody's Business, at 7 p.m. We'll have an expert panel to follow. And also, come on down to Sage for our strawberry tea on Thursday, June 15th. We will have entertainment by Northern Heart. And note the time change. It's going to be at 1 o'clock, not 11 o'clock. Northern Heart will start playing at 1. We expect by June 1st that the Sage will have masking will become an individual decision. We'll know more at the beginning of June. You can contact us at agingwithpride@gmail.com. We'll see you all next week.
Thank you.